Hi, this is Usha. Welcome to Rathod's IAS classes. Today in this lecture, we are going to see the remaining part of the fundamental rights. So in this lecture, we are going to discuss about the cultural and educational rights that include Article 29 and Article 30 of Indian Constitution. And we are going to see the Article 32 which talks about the right to constitutional remedies. And we are also going to see the Article 33 which is talking about the armed forces and the fundamental rights, and Article 34 which talks about the martial law and fundamental rights, and Article 35 about the some of the important thing regarding the affecting of the fundamental rights. And later on we are going to see the some other rights which are not the part of the fundamental rights but they are present in the other parts of the constitution, that is the legal rights as well. So let's get started with our discussion. So let us see the first one, that is the cultural and the educational right. So it includes the two articles, Article 29 of Indian Constitution and also the Article 30 of Indian Constitution mainly talks about the cultural and the educational rights. So let us see the Article 29 first. So Article 29 mainly talks about the protection of the interest of the minorities. So if you see the exact wordings of the Article 29, it says, it provides that any sanction of the citizens residing in any part of the India having the distinct language, distinct script, culture of its own shall have the right to conserve the same. So whenever it talking about the mainly the interest of the minorities. So what are those minorities? These people have the distinct language, and we can also see the distinct culture, and also we can see the distinct script as well. So this is the right which is mainly protect the interest of the minorities, mainly to safeguard or right to conserve the distinct language, script, culture of its own. So if you see this right, it is not available to the foreigners, it is available only to the citizens of the India. So if you see the second statement, it says, no citizen shall be denied admission into any education institution which is maintained by the state or receiving the aid from the state funds on the grounds of any religion, race, caste and the language. Okay, so this is the important thing. And if you see the first provision, it is the second provision, that is Article 29 subclass 2, and this is the Article 29 subclass 1. So if you see this first provision of this Article 29, it mainly talking about the right of the group, but if you see the second provision, it says that the right of the citizen. So when you are talking about the protection of the interest of the minorities, there are two important things. The first one is there shall be the right to conserve the distinct language, script and also the culture or the customs of that people. And the second one is no citizen shall be denied admission into any education institution maintained by the state or the aid which is given from the state funds only on the grounds of religion, race, caste and the language. And the first provision we are talking, that is the right to the group of the people, and the second provision is the right of the citizen or as any individual, that is irrespective of any community which he or she belongs to. So this is the important thing, okay. And if you see this Article 29, it grants a protection mainly both the religious and also the linguistic minority people. And the some important thing that is said by the Supreme Court is, Supreme Court held that this scope of this article, it is not necessarily restricted to the minority only, as it the community assumed to be. That means it is not only restricted to the minority, it can be extended to the other people as well. So the Supreme Court also held that the right to conserve the language includes right to agitate for the protection of the language as well. So this is the important thing which is under the 29 of Indian Constitution. And let us see the next article, that is 30. And this Article 30 mainly talks that right of the minorities mainly to establish and administer the education institution. So this Article 30, it grants the right to the minorities, whether it may be the religious, also the linguistic minorities. So according to this, there are some provisions under this Article 30. The first one is, all the minorities, they have the right to establish and also administer the education institutions of their choice. So this is the first important provision. So it talks about the right to establish and also administer the education institutions of their choice. And if you see the next one, that is the compensation amount which is fixed by the state for the compulsory acquisition of any property of any minority education institutions shall not restrict or abrogate the right to guarantee them. That means if at all any compensation, which is the amount which is fixed by the state for the mainly the compulsory acquisition of any property for any minority education institutions, then shall not be restricted based on the right that guaranteed to them. And the next one is this provision, it is not present in the original constitution. It is added through the 44th Constitutional Amendment Act of 1978, mainly to protect this right of the minorities in this regard. And let us see the next provision. It is talking about the granting aid. So in this third provision, the state shall not discriminate against any education institution which is managed by any minority. So there will be no discrimination done by the state. And the next important one is, thus under this Article 30, it is confined only to the minorities. They may be the religious minorities or they may be the linguistic minorities, and does not extend to any sections of the citizens under Article 29. So if you see I am saying the many times minority. So whether this minority it is described or defined in the constitution or it is anywhere present in the constitution. The term minority which has not been defined anywhere in the constitution. And if you see this Article 30, the right under this Article 30 also includes the right of a minority to impart the education to its children in its own language. So whenever these minority institutions that were established, then the teaching can be done in their own languages. For example, they have the different languages, correct? So in that languages, the education will be continued. So it is also the right under Article 30. So according to this Article 30, these minority education institutions are classified into mainly three types. The first one is the institutions that seek the recognition as well as the aid from the state. So the first one is they are receiving the aid and also the recognition from the state. And the second one is they seek only recognition but not aid from the state. And the third one is they do not seek either recognition or any aid from the state. So these are the three types of the education institutions that were classified under the Article 30. So let us see the next article, that is the right to constitutional remedies. In our constitution, Article 32 talks about this right to constitutional remedies. So this is one of the important thing, because Dr. B.R. Ambedkar said that this right to constitutional remedy, it is heart and soul of the fundamental rights. So let us see about this Article 32. So if you see the exact wordings of the Article 32, it says the right to remedies for the enforcement of the fundamental rights of an aggrieved citizen. So in the other words, it also said that right to get the fundamental rights which are protected in itself, it is a fundamental right. So this is very important thing, okay. So you may expect the prelims questions regarding this Article 32. So if you see Dr. B.R. Ambedkar called this Article 32, it is one of the most important article which is present in our Indian Constitution. So it is an article without its constitution would be nullity. So without this Article 32, there is nothing in the Constitution. So because of this, it say that the very soul of the Constitution and the very heart of the Constitution, it is Article 32 of the Indian Constitution. So if you see the Supreme Court also ruled that Article 32, it is one of the important basic feature of the Constitution. Hence, it cannot be abridged or taken away even by the way of an amendment of the Constitution. So if you see Article 32, which also gives the power of the Parliament mainly to amend, correct? So if you see this Article 32, it says that it is an important basic feature of the it is Article 368. So if you see the Article 368, it gives the power to the Parliament mainly to amend the Constitution. So through this Article 368 also, this cannot be amended. That is Article 32 cannot be amended. So if you see, it also contains the four important provisions. Those were, the first one is right to move to Supreme Court. So whenever your fundamental rights are violated, then you can directly go to Supreme Court, because Supreme Court, it is a guarantor and also the protector of the fundamental rights of the individuals. And the next important provision is the Supreme Court shall have the power mainly to issue the directions or orders or the writs for the enforcement of any fundamental rights. So according to the Article 32, there are 5 writs that are provided. They include habeas corpus, mandamus, prohibition, certiorari, and also quo warranto. These are the 5 writs which are provided under the Article 32, mainly for the protection of the fundamental rights of the individuals. And the next important provision is Parliament can empower any other courts to issue the directions or the orders or the writs of all the kind. But there is nothing happened here. So it is only given to the Supreme Court and also the High Court regarding this power to issue the writs. And if you see, that's the constitution that provides the president can suspend the right to move to any court of enforcement of the fundamental rights during the national emergency under Article 359. So whenever there is a national emergency is happening, the fundamental rights are suspended, and this also suspended that there is no one can move to any court for the enforcement of these fundamental rights. Here the Supreme Court has been constituted as a defender and the guarantor of the fundamental rights of the citizen. So because of this, whenever the fundamental rights of the individuals they are violated, they can go to the Supreme Court directly. Okay. So let us see the type of the writs here. This writs is a very important regarding the prelims point of view. So please focus here. So in this writs we are going to discuss about 5 important types of the writs. First one is habeas corpus, second one is mandamus, third one is prohibition, fourth one is certiorari, fifth one is quo warranto. Okay, so let us see here. Here the Supreme Court under Article 32 and the High Courts under Article 266 of Indian Constitution, they have the power to issue the writs. They include habeas corpus, mandamus, prohibition, certiorari and also quo warranto. So the Parliament under the Article 32 of Indian Constitution, it can empower any other court to issue the writs. So the Parliament have the extreme power. It can also empower any other courts. Since there is no such provision has been made so far, only we have this issuing of the writs power with the Supreme Court and also the High Court, but not with the any other court. So if you see the Article 226 now empowers all the High Courts to issue the writs. So these writs, they are taken from the English law. They are known as the Paragate of Writs. And if you see, there is a writ jurisdiction of the Supreme Court which is different to that of the High Court. So this is also very important regarding the prelims point of view. Let us once see those what are the differences between the writ jurisdiction of the Supreme Court and also from the High Court. So there are mainly 3 important differences. The first one is Supreme Court can issue the writs only for the enforcement of the fundamental rights. But in case of High Courts, it can issue the writs even in the legal rights as well. So Supreme Court, we have the issues only against our fundamental rights. But if you see in regard of this High Court, it can issue the writs not only for the enforcement of the fundamental rights, but also the other rights, they are called as a legal right. So the writ power of the Supreme Court, it is narrower compared to that of this writ power of the High Court. This is the first important difference. And let us see the second difference. Supreme Court can issue the writs against a person or the government throughout the territory of the India. But if you see the High Court can issue the writs against a person or the government only within its territorial jurisdiction. That means within its states, not beyond its states. This is the second important difference. And the third one is a remedy under the Article 32. It is itself a fundamental right. Hence, Supreme Court may not refuse the or exercise its writ jurisdiction. But if you see in the High Court, it is according to Article 226 of the Indian Constitution. So it is a discretionary power. Hence, High Court may refuse to exercise its writ jurisdiction. So itself, the Article 32 is a fundamental right. So according to this Article 32, it is saying that there is a fundamental right. If there is any violation, it allows the individual to move to Supreme Court directly. So because of that, Article 32 itself, it is a fundamental right. It may not refuse to exercise the writ jurisdiction by the Supreme Court. But in case of the High Court, it is according to 226 of the Constitution. So High Court may refuse to exercise this writ jurisdiction. These are the 3 important differences between the writs of the High Court and the Supreme Court. So it may be a direct question in the mains as well. So please focus. So let us see the writs one by one. So first writ is habeas corpus. Habeas corpus, it literally means to have a body of. To understand this, I will give you first example. Let me take myself as example. I am a citizen of India. I went out just for a shopping like that. Suddenly what happened? Policeman came and arrested me without saying any charges. Without any charges on me, policeman arrested me. So it is violating my fundamental right, correct? So whenever my fundamental right is violated, then I can go to the Supreme Court directly. But if I am in a jail, how can I move to the Supreme Court? So on behalf of me, any of my family members, either my husband, either any of my family members, they can move to Supreme Court. So there is no locus standi that can be applied here. Locus standi means whenever any person's fundamental right is violated, that person only should file to the Supreme Court. Then that is called as locus standi. So in this condition, I am already in jail. How I cannot come outside to file the petition in the Supreme Court such that any of my family members can move to Supreme Court. So in this case, the locus standi, it cannot be applicable. So it is applicable both against the public authorities and also the private individuals. So it is called as simply habeas corpus. I hope it is clear now. So if you see in this slide, it is an order which is issued by the court to a person who has detained another person to produce the body of the latter before it. So in this way, it is called as to have the body of. So in this context, the court then examines the cause and the legality of the detention, and it would also set the detained person free if the detention which is found illegal. So whenever the detention is found illegal, the court set that person free as well. So this type of the writ can be issued against both the public authorities and also the private individuals as well. So in this, there are some conditions. The writ, on other hand, it is not issued when the detention is lawful, correct? And the next one is the proceedings for the contempt of the legislature or a court. When there is a contempt of the court, that is a civil contempt or the criminal contempt, then it will not accept. And next one is detention by the contempt court. And next one is a detention outside the jurisdiction of the court. So in this case, this will be not accepted. So let us see the next important writ, that is mandamus. So before getting into the mandamus, I want to give you some example. For example, if there is a person A is there. So when there is a public authority or the public office is there, this public office has to do its work. But this public office, it is not doing the work and such that it is violating the fundamental rights of the A. So because of this office, it is not doing work, then this affecting the fundamental right of this person A. So in this time, this person can move to Supreme Court directly. So in this case, the fundamental right of this person is violated. So this person only have to move to the Supreme Court. So in this context, locus standi will apply, and it is applicable only to the public authorities, not to the private individuals. So this is about the simply mandamus. So let us see what is written in the slide. Mandamus, it literally means we command. It is a command which is issued by the court to a public official asking him to perform his official duties. So whenever this office it is not doing the work, here the court asks him to do his official duties that he has failed or refused to perform earlier. So it can also be issued against any public body or any corporation, an inferior court or a tribunal, but not to the private individuals. And this writ mandamus, it cannot be issued in some cases. So let us see what are they. The first one is against a private individual or a body, as I said earlier, to enforce the departmental instructions that does not possess the statutory force. And the next one is when the duty it is discretionary and not mandatory. In this case also we cannot command them. And the next one is to enforce a contractual obligation. And the next one is again if the President of the India or the state governors, in this case also we cannot command them. And the next one is against the Chief Justice of the High Court or in an acting judicial capacity. Then in this case we cannot issue the writ of the mandamus. And let us see the next important writ, that is a prohibition. In this prohibition, it means to forbid. So this prohibition it is given by the higher judicial authorities to the lower courts. To understand this prohibition, we have to see some example. If you see a person who moved to the court, but the judgment it is not given. So this judgment it is out of the jurisdiction of that court. Then the higher courts will give the prohibition to this court such that there will be no further proceedings that is taken by this court. So this is the understanding, how to understand this prohibition, okay. So when a person who moved to the court, then what happened? That judgment of that case will be the extra or the over jurisdiction of that court. Then the high court, then the higher court will give the prohibition to this lower court, such that there will be no further judgment will be happen in this court. So this means forbid literally. And if you see, it is issued by the higher courts to the lower courts or the tribunals, mainly to prevent the latter from exceeding its jurisdiction or uprising a jurisdiction that it does not possess. And unlike this mandamus, that directs activity, the prohibition directs inactivity. So it says that it should not act. And if you say mandamus, it says you have to do the work. But if you say this prohibition, it says you do not do the work. And if you say the writ of the prohibition, it can be issued only against the judicial and also the quasi-judicial authorities. It is not available to any administrative authorities or the legislative bodies and also the private individuals and others. So it is only applicable to judicial and also the non-judicial or the quasi-judicial bodies. And the next one is certiorari. If we say this certiorari, it means to be certified or to be informed. So let us move to some example first. So for example, if there is a person A went to the court. This court already gave the judgment. So after the giving of this judgment also, higher court can nullify or say this judgment will be quashed or nullified the judgment which is given by the court. This is called as certiorari. Certiorari means to be certified or to be informed. Again, it is issued by the higher courts to the lower courts or the tribunal, either to transfer the case which is pending or itself or quash the order which had the presented in this case as well. So it is mainly issued on the grounds of the excess jurisdiction or the lack of the jurisdiction or the error of the law. So unlike the prohibition, which is only preventive measure, but this certiorari, it is both preventive and also the curative. Okay, so this is the main difference between the prohibition and the certiorari. So if you see the writ of the certiorari, it could be issued against any judicial or any quasi-judicial, and also it is not given against the administrative authorities, same like that of the prohibition. Okay, so let us see the next important one, that is a quo warranto. Here quo warranto means simply what authority or warrant. So if at all any public officer who joined the public office, so whether this public officer have the right to enter into this job or not, that is called as quo warranto. Quo warranto means by what authority or warrant. So it is mainly issued by the court to inquire into the legality of claim of a person or a public office. Mainly to inquire the legality or a claim of a person or a public office. So if you see, hence it prevents illegal instruction of the public office by any person. And this writ can be issued only in the case of the substantive public office of a permanent character, which is even created by the statute or by the constitution. So it cannot be issued in the case of the ministerial office or any private offices as well. So this is called as the quo warranto. So by this we discuss about the 5 important rights under Article 32 of the Indian Constitution. I hope it is clear now. You will not confuse once again. So if you see the next article, Article 33 mainly talks about the armed forces and the fundamental rights. So let us see the exact wordings of the Article 33. It empowers the Parliament to restrict or abrogate the fundamental rights of the members of armed forces, paramilitary forces, police forces, intelligence agency and also the analogous forces. So in this right also the Parliament which is given the excessive powers. And the objective of this provision mainly to ensure the proper discharge of their duty and also maintenance of the discipline among them. So this is the major objective of this Article 33 of Indian Constitution. So if you see the powers to make the laws under this Article 33, it is conferred only to the Parliament but not any state legislature. So any such law made by the Parliament cannot be challenged in any court of law on any grounds of the contravention of any fundamental rights. So this is very important concept. So this is very important for the prelims as well. So if you see any law which is made by the Parliament can be challenged under the any court of law, it is under the judicial review, correct? So this article, that is Article 33 of Indian Constitution, any law which is made under this cannot be challenged in any court of the law. And let us see the next article. Article 34 mainly talks about the martial law and the fundamental rights. Before seeing this martial law, I want to give you some clarification that till now the martial law or the military rule which is not imposed in our India. So because of this exact provision of this martial law, how it will be, no one knows. So if you see this article 34, it says it provides for the restrictions of the fundamental rights while the martial law is in force or in any area within the territory of the India. So it is talking about the martial law. Whenever the martial law is imposed, there is a restriction of the fundamental rights is seen. So again, this article 34 also empowers the parliament mainly to indemnify any government servant or any other person for any act which is done by him in connection with the maintenance or restoration of the order. So it is again giving the power to the parliament. And if you see, this concept of the martial law has been borrowed in India mainly from the English common law again. So if you see this martial law, it means the military rule in short. This martial law, it is imposed under the extraordinary circumstances include war, there may be invasion, insurrection, rebellion, riot or any restrictions to law. So in these extraordinary circumstances, this martial law which is imposed in the India. So if you see, during this operation of this martial law, the military authorities, they are vested with the abnormal powers mainly to take whatever the steps they want to take. They may impose the restrictions and also the regulations on the rights of the civilian, and they can also punish the civilians, even they can condemn to the death. So till now these provisions are not clear because the military rule, it is not even imposed single time in the India. So let us see the next article. This is the article 35. Mainly it talks about affecting the certain fundamental rights. So if you see the exact wordings of the article 35, it says it lay down the power to make the laws, to give the effect mainly to certain specified fundamental rights that shall vest only in the parliament and not in the state legislature. Again, the powers are given entirely to the parliament. And it also says that the provision which ensures there is a uniformity throughout the India with regard to the nature of those fundamental rights and the punishment for the infringement as well. So this provision which ensures the uniformity throughout the India with the regard to the nature of those fundamental rights and also the punishment of their infringement. So if you see in this direction, Article 35 which contains the following provisions. So let us see those provisions as well. The first one, it says the parliament shall have the power to make the laws with respect to the following matters. So again, in this article 35 also we see the entire power which is given to the Parliament of India but not to the state legislature. So the parliament have the power to make the laws. They include, first one is the prescribing the residence. They include, the first one is the prescribing the residence as a condition for the certain employments or the appointments in the state or in the union territory or in the local authority or other authority according to the Article 16. So Article 16 talks about the no discrimination in the public employment. So it also says that the prescribing residence, it also comes under the power of the parliament. And the next important one is empowering the courts other than the Supreme Court and the High Courts to issue the directions, orders and also the writs. It comes under the Article 32. We already studied that. And the next one is the restricting or abrogating the application of the fundamental rights to the members of the armed forces and the police forces. It comes under the Article 33 of Indian Constitution. And the next one is indemnifying the government servant or any other person for any act done during the operation of the martial law. It is talking about the Article 34 of Indian Constitution. And the next one is the parliament shall have the powers to make the laws for prescribing the punishment for those acts that are declared to be the offences under the fundamental rights. So again, in this case also parliament have the power. So in this second one, the following are including, they include the untouchability under Article 17 and they also include the Article 23 mainly talks about the right against exploitation, that include the traffic in the humans and also the forced labor and also the child labor. And the next one is any law in the force at the commencement of the Constitution with respect to any of the matters which are specified above, mainly to continue in the force until altered or repealed or amended by the Parliament. So whenever there is any provisions which are made from the commencement of the constitution, if at all any change want to made in the constitution, the power which is given to the parliament, these changes are made by the parliament made into the constitutional amendment acts. So if at all there is any constitutional amendment act which is not made, then it will continue like that only. So let us see the next important one, the rights outside the part 3 of the constitution. So besides these fundamental rights, it are included in the part 3 of the Indian constitution, which are mainly talking from the article 12 to the article 35 of the Indian constitution. There are also certain rights which are contained in the other parts of the constitution. Thus are, the first one is in the part 12 of the constitution. It talks about no tax shall be levied or collected except by the authority of the law, according to the article 265 of the Indian constitution, which is present in the part 12. And the next important right is no person shall be deprived of his property save by the authority of the law, according to article 300A, mainly in the part 12 again. And the next one is trade, commerce and intercourse throughout the territory of the India shall be free, according to the article 301, again in the part 12 of the constitution. So these are the some important articles which are present outside the part 3 of the constitution. So by this we are winding up today. Before winding up, I want to give you a small announcement. So all the people who are watching these polity lectures and also the art and culture lectures, they are asking for the PDF. I made this PPTs mainly from the books like the Laxmikanth and also the Nitin Singhania. So I don't want to provide these PDFs because you have to refer the Laxmikanth and also the Nitin Singhania. So before going into exam, you should be thorough with the polity, because the polity is a very important subject. So you may expect 15 to 20 questions from the polity. So if you want to attempt all those polity questions with accurate answers, then you have to read this polity. Okay, don't worry about the PDFs. Please refer this Laxmikanth twice or the thrice before going into exam. Then you will be thorough with this polity. So in the same way, you have to watch the videos as well. Whenever you are watching these videos, it will make you to understand the concept easily. Because if you say some terminology in the Laxmikanth, it is very difficult to understand. So if you watch these videos and after watching these videos, if you are referring to this Laxmikanth, it will be very easy to you to understand the concept, and also you can easily remember the facts as well. So by this, I want to conclude today. I hope you understand this lecture. Please subscribe to my channel. Please do like, share and comment my lectures. Thank you so much.